This is docket 9814 CE 100, the application for a CPCN of High Noon Solar Energy for authority to construct a solar electric generating facility. This is Michael Newmark, the Administrative Law Judge for the PSC. We're here on Zoom for the party hearing session. We'll be holding public hearing sessions at 2 p.m. and 6 p.m. for members of the public to comment. We're also accepting comments up until Friday, March 3rd. With for members of the public, those comments may be filed on the commission's website or mailed to us by U.S. mail. They just need to be received by Friday. We have many comments on file so far. I don't have the precise number, but I'll review those and put them in the record, as well as the documents we identify here today, its exhibits and written testimony, and any comments are made by parties, commission staff, cross-examination questions, etc. They'll be made part of the record and recorded on the transcription from today's hearing. We're also streaming this live on YouTube, and there will be a recording preserved on our YouTube channel. So we're going to take, well, I do want to do party appearances. We're going to do a little bit of the process out of order because I know that there are some witnesses that need to be excused before, well, early on the process, one before 10:30. So we're going to take them out of order. But first, let's just get party appearances. We'll start alphabetically here with High Noon Solar, who's representing the applicant.
Good morning, Your Honor. This is Delaney Brewer with Reinhardt Berner Van Duren, representing High Noon Solar.
All right, thanks. Public Service Commission.
Good morning, Your Honor. Stephanie Bedford, Assistant General Counsel, representing the Public Service Commission.
And Renew Wisconsin.
Good morning. This is Michael Vickerman, representing Renew Wisconsin.
All right, great. So like I said, we are going to do this a bit out of order. I think we can switch right to taking the testimony of Samantha Whitens, and then we'll get back to our normal process. We'll review the offered evidence list and any comments, concerns that have been expressed on that list. We also have a applicant witness we'll take right after Samantha Whitens. So let's have Samantha, let's have her call her up and have her.
Thank you, Your Honor. The commission calls Samantha Whitens to the stand.
Okay, great. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Please state your name for the record.
Samantha Whitens.
And what is your position with the Wisconsin DNR?
I am a stormwater engineer. I review the stormwater plans.
And did you file or cause to be filed direct testimony in this docket?
Yes.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
And do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross.
All right, any questions for the witness?
None from the applicant.
Okay.
None from Renew.
All right, thanks. Okay, so we will excuse you. Thanks very much. Glad to get you on your way. So if there are no objections, we'll take witness Hegany next. I think that's the other witness we need to fulfill their appearance at the beginning of the hearing. So how does that sound for everyone?
That works for us, Your Honor. I would just note that he does have a few new exhibits pursuant to your comments. And I believe those were just circulated by email. I apologize for getting those to you so late.
No, that's fine. I wasn't expecting. Thank you for doing that. I guess I didn't think that through. Yes, so wasn't expecting to get them. I didn't think I was emailed those. I didn't notice that. If you wouldn't mind forwarding that, maybe if Stephanie or you could.
Yep, it just went out actually.
Oh, okay.
6, so you may be about to receive it. Actually.
Oh, okay. So maybe we're taking this too fast.
I think we would be okay going through your comments before we
Okay.
take his testimony, if that's easier.
Sure. And how many exhibits are you filing then? Was it more than just the one extra?
For Mr. Hegney, we actually have two. We have the one requested, which is the final GNA, and then we have the initial letter sent out ahead of the GNA.
Okay. Okay, great. Yeah, well, yeah, I think it's more for, yeah, I don't know if we have any specific questions on that, but why don't we call him now and see how far we can get before the email comes through. All right, I see him there. So I'm going to ask you if you wouldn't mind, witness Hegney, to turn your background off. Unless there's something we don't want to see. There we go. Perfect. Okay, great. So let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Yeah, you want to unmute?
I do.
Okay, perfect. Okay, go ahead.
Morning, Mr. Hegney. Could you please state your full name?
My name is Samuel Hegney.
And where are you employed and in what capacity?
I'm a senior analyst in renewable development at Invenergy.
And have you prepared and caused to be filed in this proceeding direct testimony consisting of 8 pages and 2 exhibits?
Yes, I have.
And do you have any corrections to that testimony?
I do not.
If I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes, they would be.
With that, Your Honor, I would move to incorporate Mr. Hegney's testimony into the record if that's necessary, unless we're going to talk about that after his testimony.
Let's do it before, so we don't forget. So any objections to those filings being accepted for the record?
None from the commission, Your Honor.
None from Renew.
All right. Okay. So anything else for the witness besides my comments, clarifications?
Yeah, yes, Your Honor. We were just going to walk through a little additional testimony to address some of your comments.
Okay, and just so you know, I did just receive the email, so we have those documents to reference. I will we won't display them on the screen share because I see some of them are maybe confidential. So at least there's one that's a public version. I don't know if there's a. So you didn't send the confidential version by email? Is that what should I?
We did not send correct. We did not send the confidential version by email.
Okay.
So if you'd like to display it, the version you have by email is fine.
Okay, but that'll be filed on Earth.
Correct.
Okay, great. Yeah. Okay. Yeah. Do what you need to do. I'll just follow along here.
Okay, great. Thank you. Mr. Hegney, have you reviewed the questions received from ALJ Newmark in the offered evidence list provided on February 27th?
Yes, I have.
And based on those questions, how many non-participating property owners are adjacent to the proposed the proposed project?
There are 82 unique non-participating landowners with land adjacent to parcels that are potentially hosting above ground facilities.
Thank you. And does High Noon Solar have a standard form for a good neighbor agreement?
Yes, it does. That form agreement has been added to Appendix W to the application.
And can you describe the process by which a particular good neighbor agreement takes final form? In other words, what are the terms and conditions upon which High Noon Solar and the neighbor would negotiate?
Yes, so we offer the good neighbor agreements to landowners with residences nearby the project. Our first step is to send a letter introducing the project and offering to enter into a good neighbor agreement. That letter is being offered as Exhibit High Noon Solar Hegney 3. If a landowner responds to that letter, our second step is to share the form good neighbor agreement with them. And then our local representative High Noon Solar's local representative will meet with the interested landowner and walk them through the terms of that agreement. The next step would be to gather information from the landowner so that High Noon Solar can understand property specific conditions and concerns that may need to be addressed by the agreement. This includes asking detailed questions about the landowner's preferred solutions to property specific and as well as more general concerns. Items commonly discussed during this step can include placement and maintenance of vegetative screening, minor adjustments to project infrastructure, and other actions to address specific concerns that are unique to the property. Step 4 is to then analyze the detailed property specific information and any additional requests of the landowner and work with them, the landowner, to reach a mutually agreeable solution that can be memorialized in a good neighbor agreement. And then after that agreement is reached, the final good neighbor agreement will be drafted and executed by both parties.
Thank you. And has High Noon Solar approached the non-participating landowners adjacent to the project with this standard form of the good neighbor agreement?
Yeah, High Noon Solar sent an introductory letter about the good neighbor agreement to 62 non-participating residential property owners adjacent to or near the proposed project facilities.
And how many good neighbor agreements has High Noon executed with these landowners to date?
High Noon Solar has executed 2 good neighbor agreements thus far, one of which was with Mr. William Simpson. That agreement is being offered confidentially as Exhibit High Noon Solar AGNI 4, and several additional agreements are in different stages of the process.
Thank you, Your Honor. No further questions.
All right. Just a quick follow-up. Just was wondering, Witness Hagney, you said that good neighbor agreements were sent to adjacent property landowners and those that are near. And I'm just wondering what classifies a good neighbor, a neighbor to be near the project in order for you to consider them eligible for a good neighbor agreement.
We looked at, I guess, site-specific or individual conditions there. I don't think there is one hard rule.
Mm-hmm. Okay, just curious. Great. So anything else, Attorney Brewer?
No, Your Honor, the witness is available for cross.
Okay, perfect. So any questions for the witness?
None from the commission.
None from Renew.
All right, great. Okay, well, thanks very much. You're excused. And I believe we have all the witnesses that we need to accommodate for timing purposes. And that's anyone else we need to take now? Okay. So let's return to our typical process. We'll just review the offered evidence list. And so I'm just going to need to rejigger the screen here. That'll work. Okay, actually, let me show you the comment panel. I don't know how that's going to look to you. You may need to follow along on your own your own document because this could be difficult to read. So I guess first of all, just in terms of filing, I guess we just stay on the record for this. But in terms of filing, or just the accuracy of the offered evidence list, any documents misfiled or any mistaken documents or just documents that I omitted by accident in terms of what we're expecting to offer for the record?
No, Your Honor, not from the applicant.
Okay. Yeah, okay, good. Okay, so in terms of comments, we can, of course, I think we'll need to delve into Renew Wisconsin with a little more detail, but everyone except Renew Wisconsin, any comments that there are questions about?
None from the commission.
Okay, applicant.
Your Honor, we plan to address your questions in the remaining SIR rebuttal.
And in terms of refiling instructions, any questions about that?
No questions.
All right. So let's address Renew Wisconsin then. So we have essentially it's the Vickerman 3 exhibit, and then there is a portion of Vickerman's testimony that's related to the exhibit. So there are issues that I had expressed about that. And I sent a preliminary ruling as part of the offered evidence list to give everyone ample notice and an understanding of where I'm coming from, what my understanding of my opinion is on this. I think since I sent it to you, I did modify my thinking about this slightly. So I think it may be useful to read this into the record first before I take arguments about the ruling, so we're all on the same page. I mean, one of the biggest changes is that I had originally categorized the document being offered as Renew Exhibit 3 as a study. And looking at it a little more critically, I noticed it's really a blog post from a website, so I changed that category, that classification of the document, to just refer to it as a blog post. And then I did add a few more details that I think is only fair to give you the opportunity to hear that first before you tell me your opinion on the preliminary ruling. So let's get started with that. So I'll read this off for the record. So Wisconsin statute 22745 sub 1 provides the standards for accepting or rejecting evidence into the record. So quoting that statute, the agency or hearing examiner shall admit all testimony having reasonable probative value, but shall exclude immaterial, irrelevant, or unduly repetitious testimony. So Exhibit Renew Vickerman 3 contains a blog post dated September 21st, 2021 from the website betterenergy.org titled "The True Land Footprint of Solar Energy." For the following reasons, this tribunal rejects the offer of Exhibit Renew Vickerman 3. Of course, just a preliminary ruling at this point. First, the post lacks reasonable probative value. The post attempted to show on page 5, and I'm referring to the exhibit PDF page numbers here. So the post attempted to show how the scale of solar development compares to land available for cultivation at the county scale, an indicator of risk to agricultural economic activity. Then the post claimed to find on page 3 that current and proposed solar land uses are a fairly minimal percentage of total county land use when compared to other land uses. And the post concluded on page 3 that solar development is a minimal risk to the economic base of agricultural communities as measured by land conversion. The post on page 4 based its conclusion on the following assumption. In cases of agricultural land conversion, the economic risks of conversion are closely associated with the amount of land being converted. However, the post failed to demonstrate how it reached this underlying conclusion. Furthermore, Direct Renew Vickerman provided no insight into this question. The sponsoring witness made no claim to having contributed to the post or having any knowledge of how the underlying data used in the post were gathered, or how the underlying assumptions used in the post were developed. The witness claimed to possess no specialized expertise to explain the post, provide context to the post, or apply the conclusions presented in the post to the facts of this proceeding. Because the post failed to demonstrate how the post reached the conclusion that economic risks of agricultural land conversion are closely associated with the amount of land being converted, And because witness Vickerman can provide no insight into the matter, no rational mechanism exists to test the accuracy of the post's underlying premise. Because no rational mechanism exists to test the accuracy of the post's underlying premise, the commission lacks the means to weigh the post's credibility. Also, because no rational mechanism exists to test the accuracy of the post's underlying premise, the commission lacks the means to determine whether the post's conclusion in any way relate to either the post's regional comparisons of the scale of solar development to land available for cultivation, or witness Vickerman's comparisons of the scale of the proposed project to land available for cultivation in Columbia County. For these reasons, the post lacks reasonable probative value. Because the post lacks reasonable probative value, this tribunal rejects its offer as record evidence. Second, the post has no relevance to this proceeding. While Renew Wisconsin appears to present the post for the purpose of demonstrating that under Wisconsin statute, section 196.491, sub 3, sub D, paragraph 6, the proposed facility will not unreasonably interfere with the orderly land use and development plans for the area involved, the post entirely failed to address that issue. First, the post contained no analysis of the project's impacts on the project area. Second, the post admits on page 5 that its scope involves a different question than whether solar is an appropriate land use given community or state priorities from a natural resource, in parentheses, prime farmland, close parentheses, perspective, or a cultural, parentheses, rural character, comma, view sheds, close parentheses, perspective. Third, the post claimed to find on page 3 that current and proposed solar land uses are a fairly minimal percentage of total county land use when compared to other land uses. For purposes of this proceeding, this finding is meaningless without having analyzed the project's impact, whatever its size, in the context of the area involved as required by 196.491, 3D6. By way of demonstration, when compared to the proposed project at its current location, would the project proposed at a location viewable to visitors of Old World, Wisconsin have the same impact on orderly land use and development plans for the area involved as the current proposal? Finally, the economic impact study located in Exhibit HNS Application Appendix X provides a robust and specific demonstration of the project's relation to and impact on the community that is relevant to the proceeding. To the extent the post touches on the same matters as the economic impact study, the post represents a mediocre and undue duplication. To the extent the post raises other matters, the post, as described above, presents nothing relevant to this proceeding. For all these reasons stated above, this tribunal shall not receive Exhibit Renew Vickerman 3 into the record. And then something I added, so you'll see this for the first time, but consistent with this ruling, Renew Wisconsin shall refile Direct Renew Wisconsin that strikes the portion of that testimony that relies on the post. So I identify that as Direct Renew Vickerman, page 12, line 15 through page 13, line 10. So at this point, I can take the arguments of parties and commission staff on this preliminary ruling. So let's start with, I think we should probably start with Renew, and then we can turn to the applicant. If we could turn your video on, please. Oh, I see you there. You have it on. Sorry. Go ahead.
Thank you, Your Honor. So the study follows the question that I ask of myself, which is, what is your view on the project's impact on Columbia County's agricultural land base? And then I engage in statistical analysis of how much cultivated land there is relative to the county. and how much of that is considered active cultivated agriculture. And the definition is, I think, actually pretty meaningful. And it's defined here. My point in bringing up the blog post, and it is a blog post with some analysis in it, is that the percentage of actively cultivated agricultural land is consistent with what is being observed in other parts of the Midwest. It was just merely a reference for how much land is taken up with this particular project. I was planning to add a sentence at the end of that response to the question. And that sentence was, this analysis supports my observation that High Noon Solar Project will have a de minimis impact on Columbia County's agricultural land base. And I would say that that does actually respond to, I don't quite see it here, but the question of orderly land use. If it's a de minimis impact, then I think it's fair to conclude from that the project will not unreasonably interfere with the land use patterns presently within Columbia County.
Okay, so I just wanted to be clear, and I think maybe when you referred to my question, were you referring to the question I had of your testimony? How does the post relate to how does the post support your testimony? Is that?
That's correct.
Okay, right. So I thank you for, I mean, there would be something we need to add to testimony. Yeah, I see that. And so I don't know if we're far off on this, but I think what I would be striking, according to my ruling, would be starting on line 15 of your page 12. So it would include, you would be still testifying to the calculations of land use in Columbia County.
Yes, the statistical analysis that precedes the citing of that blog post relates specifically to Columbia County.
Right. It doesn't compare it to the size of the project, which
yes, it does, right at the beginning.
Okay, good. Oh, yes, there you go. Right. Okay, good. So I guess the issue I still have is drawing the conclusion that a de minimis amount, that whether you call it de minimis or amount, the actual amount that we have in front of us, what is the impact to orderly land use and development plans? I still don't believe the post has evidence that we have the means to find credible to make that connection. So it simply states that as its own, as an underlying assumption, but it doesn't show us how it reached that conclusion. So I think comparing the size of the project to what you consider to be agricultural cultivatable land is fine, and I think that should stay in. But drawing the conclusion that the size matters is not supported by the study or by the blog post or anything that I see that that you're offering here. So I think the commission can draw its own conclusions when it looks at those facts, and that's fine. But I don't know if we can give it the assurance that there's some sort of analysis that supports that conclusion, at least based on this blog post. So so I think in terms of that, I think that I would keep my ruling in terms of how you're characterizing, in terms of your counter argument. I think I would still need to keep my ruling to reject the blog post and its underlying assumption. So let me hear from the applicant if they have any further argument on this.
Thank you, Your Honor. I think to the extent that Renew is relying on this blog post as a citation for a definition or for the specific objective statistics in the blog post, we certainly can see how that would be relevant and would not object to that. Obviously, we agree that our economic analysis is very robust, but we have no objection to Renew citing to this blog post for these purposes. I understand your concern with the conclusion, and I guess if that's the concern, perhaps we could limit what's struck from the testimony to, I believe, starting on line 8 of page 13, where that conclusion is sort of relied upon. But with respect to the percentages and the comparisons, the applicant has no objection.
Okay. Yeah, I was also concerned about how those numbers were derived, and there was no source given or methodology given for, and we have no one that can speak to the methods or the source of the data. So I think there are some sources cited. Yeah, it doesn't, it says maps created by source. Okay, so the source is cited, but the methodology of coming up with these maps and these tables are not explained. So that's where, I'm also thinking in terms of the statistics provided in the post are questionable, and we don't have a mechanism to get further clarification on how those numbers were derived, and what exactly how the raw data gets presented here. It's a disconnect that we can't test even if we wanted to. So so that's another issue with the study. That's what I mentioned in my ruling about talking about the underlying assumptions and data being not having no reasonable method to test the credibility of that. So it's I think there is evidence in terms of how the project fits in the community, and it's in order. This is obviously supporting the project. There's other evidence that shows the project is supported, is consistent with community interests. I don't think we really, the record is really losing a whole lot here. Perhaps there's another study or an expert that can be called in the future case that can make this, connect the dots here and make these claims that in a way that we can ensure their credibility. But I don't think it's at this time warranted to use the blog post as the basis for drawing these conclusions. And I don't think we can rely on the numbers that it's presenting without any further expert or background. So I know we haven't heard from commission staff. Did staff have any opinion on this?
No, staff takes no position on this ruling.
All right. So I'm going to stick to that ruling. So we'll have Exhibit 3 will not be received, and if we can have renew refile with striking page 12 line 15 through page 13 line 10. Yeah, and it's not an invalid point to make. I just think we need to have better facts to back it up. And yeah, so I think that's all we have to do on that. So we'll just have you refile. Oh, the other issue with Vickerman is just the list of the exhibits in direct. I think that's going to have to change anyway, but just so you know that you want to correct that as well when you refile.
Yes, I know. Thank you.
Okay, great. Thanks. Okay, so we have somebody new. We can just go off the record for a second. I see you joining here, iPhone. Welcome to the hearing. Just want to make sure if you're a member of the public, is that correct? You're just observing the hearing at this point? Okay, I see you're muted, and I'm going to turn your screen off as well, your video, but feel free to stay on the line to observe the hearing. Thanks. All right, so we can continue with the applicant witnesses. So go ahead and call your next witness.
Thank you, Your Honor. And just to facilitate some of our witnesses' schedules, we have a slightly different order than proposed in the offered evidence list. Is that okay?
Yeah. Witnesses order is up to you.
Okay, thank you. The applicant calls Dr. David Loomis.
Okay. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Oh, we need to turn your mic on. Should have told you that before.
I do.
All right, go ahead. Thanks.
Good morning. Would you please state your full name?
My name is David Glenn Loomis.
And where are you employed and in what capacity?
I am president of Strategic Economic Research, LLC, and I'm also a professor of economics at Illinois State University.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 8 pages and 1 exhibit?
Yes, I have.
And do you have any corrections to your testimony?
I do not.
If I asked you the questions set forth in your testimony today, would your answers be the same as set forth in your written testimony?
Yes, they would.
Your Honor, I'm not sure if we need to move to incorporate or if the offered evidence has been incorporated.
Okay, I'll just stop you there. So we have our offered evidence list, and we've reviewed that for any corrections that needed to be made. So at this point, and there were none. So at this point, we can, I'll accept all the filings that appear on the list for the record, except for the ones that need to be corrected or are subject to the ruling that we just made moments ago. So all those documents are in the record as they appear on the list.
Thank you. With that, Dr. Loomis is available for cross.
All right, any questions?
None from the commission.
None from Renew.
All right, thanks. And nothing from me. So thank you very much. You're excused.
Thank you.
High Noon Solar next calls Mr. Maroos.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Good morning. Can you please state your full name?
Michael S. Maroos.
Thank you. And where are you employed and in what capacity, Mr. Maroos?
I am employed at Maroos & Company located in Park Ridge, Illinois. I am president of Maroos & Company. I am a real estate appraiser and consultant and have the general certification appraisal license in the state of Wisconsin, and also hold the MAI and the CRE professional designations.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 6 pages?
Yes.
And do you have any corrections to that testimony?
No.
If I asked you the questions set forth in that testimony today, would your answers be the same as in the written testimony?
Yes.
Thank you. And with that, Mr. Maroos is available for cross.
All right. Any questions?
None from the commission.
None from Renew.
Okay. Thank you. You're excused.
Thank you.
High Noon Solar next calls Mr. Hankert.
All right. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Great.
Good morning, Mr. Hankard. Can you please state your full name?
Michael Hankard.
Thank you. And where are you employed and in what capacity?
I am employed at Hankard Environmental, Inc., which is a firm that I own. And in the capacity, I am the principal acoustical consultant. So I'm responsible for everything from the taking of measurements and analyzing noise and reviewing reports.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 10 pages and 1 exhibit?
I did.
And do you have any corrections to that testimony?
I do not.
And if I asked you the questions set forth in that testimony today, would your answers be the same as set forth in the written testimony?
Yes.
Thank you. And with that, Mr. Hankard is available for cross.
Okay, questions from commission staff
No, Your Honor.
and Renew?
No, Your Honor.
Okay, thanks, you're excused.
Thank you.
High Noon Solar next calls Mr. Hartzig.
Okay. Raise your right hand and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right.
Good morning, Mr. Hartzig. Can you please state your full name?
My name is James Hartzig.
And where are you employed and in what capacity?
I'm employed by Invenergy as a manager on the vegetation management team.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 7 pages and 1 exhibit and rebuttal testimony consisting of 3 pages?
Yes, I have.
And do you have any corrections to that testimony?
Not at this time.
If I asked you the questions set forth in that testimony today, would your answers be the same as set forth in the written testimony?
Yes, they would.
Thank you. And Your Honor, we do have some sir rebuttal.
Okay, yes, could do that first, thanks.
So Mr. Hartzig, have you reviewed the questions posed by ALJ Newmark in the offered evidence list provided on February 27th?
Yes, I have.
And based on those questions, can you please provide your understanding of the terms under array and buffer zones as used in your rebuttal testimony?
Yes, my understanding of the term under array are the soil surfaces and areas directly underneath our arrays and the areas between those array rows as well. My understanding of the term buffer areas are those areas within the fence line and just outside of those array areas that encapture portions of the project area.
And do those buffer zones have more flexibility with respect to vegetation establishment and maintenance than the under array zones?
Yes, those areas are more flexibility for species determination due to lower construction constraints. Yes.
Thank you. And can you explain what you meant by the term site stabilization in your rebuttal testimony?
Yes, the way I define site stabilization closely resembles that as outlined in the WIPD's permit, which is that all land disturbed by construction activities will be vegetated through permanent vegetative species, and those that can reach 70% density of comparative stabilization measures.
Thank you. And when you say the WIPD's permit, do you mean the WIPD's permit for stormwater associated with land disturbing construction activity?
Yes, those permits that would apply to projects like this.
Thank you. What elements would you evaluate to determine site stabilization at the High Noon Solar site?
The way we would determine site stabilization is the proliferation of sod forming grasses that would deter erosion through soil particle detachment, promoting infiltration of stormwater across the ground surface, and to suppress any noxious or invasive weed species from proliferating across the site, which could deter the establishment of more desirable species.
Thank you. Have you reviewed DNR witness Stacy Rose rebuttal testimony?
Yes, I have.
And can you please share your opinion about increasing the number of orb or flowering species at the High Noon solar site?
Yes, at this time, we are mostly focusing on our vegetative objectives with the introduction of our cool season grasses and sod forming grasses under those array areas. We are not open to increasing the number of forbs or pollinator friendly species in those areas.
You noted that it's difficult, there's difficulty with converting agricultural fields to grasslands. Can you explain why it's difficult to convert such agricultural fields?
Yes, I can. Agricultural fields have an inherent seed bank in those soils that often consist of very aggressive weed species. Farmers in these types of areas address that by broadcasting large amounts of herbicide. Invenergy's approach to that is to, instead of using large amounts of herbicide and broadcasting those chemicals, is by introducing vegetative species that quickly establish and outcompete those weedy species.
Thanks. And can you maybe provide some more detail on High Noon Solar's approach to managing weeds without the broad herbicide application?
Yes, so we just want to limit our use of herbicides. We just want to spot spray those in only areas that are needed when practicable. And we are promoting, those vegetative species that can outcompete weeds by planting them at the appropriate time.
And is this approach a one-size-fits-all approach to all of the agricultural land around the project?
No, it is not.
So how do you determine the specific approach for the properties around that will be part of the project area?
Given the complexity of these landscapes, we often give questionnaires to landowners asking them what weed species that have been problematic traditionally on their fields, and by collecting soil samples to determine, what fertilizers or amendments may be needed to promote the establishment of more desirable species.
And how can adding additional forb or flowering species affect this approach to vegetation management?
Our concern with forbs and pollinator-friendly species is that they germinate much more slowly than the desirable species we promote. They are more difficult to maintain. So that allows some of these more aggressive agricultural weeds in the inherent seed bank to, proliferate through the project during those times of germination.
And do the forb and flowering species generally grow in even layers or bunches across these properties?
When we consider these types of species, we recognize that most pollinator-friendly species grow pretty tall. Invenergy has an 18-inch height requirement on vegetative species in those under array areas. That limits us on which types of forbs and pollinator-friendly species we can use for consideration, since most of those species produce seed head and nectar well beyond that 18-inch height requirement limit.
So you mentioned the 18-inch limit. Aside from weed suppression, are there other reasons why you disagree with adding forb and flowering species, including ones that may extend beyond that 18-inch limit?
Yes, we also have to consider that there are shading effects that vegetation growing above 18 inches have on panel efficiency, and there's also concerns through insurance purposes that dense, robust vegetation could cause concerns for fire risks.
Thank you. And is it the density of the vegetation that increases the fire risk, or is it the height of the species?
Yes, it's mostly the height and with consideration to the robust density as well. Understood.
Thank you. So are there other places on the project area that will be planted with additional forb and flowering species?
Yes, we
stop you there. Is that already covered in the record?
I believe, Your Honor, some of it may be in the vegetation management plan
Okay.
strategy, excuse me.
Yes, I don't know if we need to get into
We
the
can
other
forego that
areas.
question.
Okay, thanks.
Mr. Hartzig, in your rebuttal, you indicate you indicate agreement with DNR's recommendation to add wild lupine to seed mix to quote to the extent practicable. Can you clarify what you meant with that statement?
Yes, we have identified pollinator habitat zones within the project area where we would actually certainly consider the inclusion of wild lupin in those areas. And if we could designate those to the pollinator habitat zones.
And are you aware of the heights to which wild lupin can grow?
Wild lupin can grow to as high as 24 inches, which would make them more ideal for those buffer zones outside of the under array and between array areas.
Thank you. And do you have any response to Ms. Rowe's proposed alternative to require additional forb and flowering species?
I believe her alternative is to review the vegetation management plan during its development. We are not in favor of that, as that could add time to that process of developing that document and deterring our construction timelines. If DNR would like to, include their comments and review as part of that process, we would ask that they do that in a very timely manner.
Thank you. And do you have a specific recommendation for the amount of time in which DNR would or commission staff would be required to respond or provide any comments on that plan?
We see that to be as time efficient as possible and to meet construction timelines and deadlines, that we would open that up to a 14-day deadline to get a review and comments back from DNR.
Okay, thank you. Your Honor, no further questions. The witness is available for cross.
Okay, perfect. Thank you. Thanks for addressing my comments and questions. I did have one follow-up. Not sure if we covered specifically this one. It was the last one. And let me just read this out. You may have some nuances in your answer based on what you just said, but share your opinion about increasing the number of forb flowering species or pollinator-friendly species in the under array area after the site becomes stable.
Yes, Your Honor. So once we've met our vegetation objectives, which is site stabilization and the permit closure through the WD, WIPD's permit for construction practices, as previously noted, we would be open to considering, the inclusion of more of those forb and pollinator-friendly species once we've achieved those objectives and permit closeouts.
And that's in the under array area?
Yes.
Okay. I'm assuming you would have the 18-inch limitation.
That's correct. We'd have to determine species that meet that 18-inch height requirement.
Okay. So if that's after the closeout of the approvals, I'll just say it like that because I'm not sure if I caught all the terminology. This would need, then how would what process would we have for that situation to occur? It would.
We would either consider interseeding those under array between array areas with, species for consideration for forbs and pollinator friendly species, or broadcasting those species where appropriate.
Would you need would it be feasible to put that in the vegetation management plan, or is it something that would occur separate from the plan?
We see that as outside of the plan, as our plan really focuses on our vegetation objectives, which again is through site stabilization and weed suppression.
Okay. Well, I guess I'll leave it to others to figure out how that would get done, what kind of process that would involve. But that's something that the applicant is willing to consider.
Yes, Your Honor.
Okay, all right. Okay, that's all I have. Any questions from staff
No questions from staff.
and Renew?
No questions from Renew, Your Honor.
Okay, well, thanks very much. Oh, anything from the applicant, any redirect?
No, Your Honor.
All right. Okay, thanks. Thanks for the help there. Appreciate the answers you've given. You're excused. You're excused.
Your Honor, High Noon Solar next calls Miss Wilson.
Okay. There you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right.
Good morning, Miss Wilson. Would you please state your full name?
Jamie Wilson.
Thank you. And where are you employed and in what capacity?
I'm employed at Invenergy. I am an environmental manager on the environmental compliance and strategy team.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 16 pages and 1 exhibit, and rebuttal testimony consisting of 3 pages?
Yes, I have.
And do you have any corrections to that testimony?
No, I do not.
If I asked you the questions set forth in your testimony today, would your answers be the same as set forth in the written testimony?
Yes, they would.
Thank you. And with that, Ms. Wilson is available for cross.
Okay. Any questions from staff
No questions, Your Honor.
and Renew?
No questions, Your Honor.
Okay. Thanks very much. You're excused.
Thank you.
High Noon Solar next calls Mr. Johnson.
See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right.
Good morning, Mr. Johnson. Can you please state your full name?
Cooper James Johnson.
Thank you. And where are you employed and in what capacity?
I am a senior manager of renewable development at Invenergy.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony of 15 pages and 1 exhibit?
Yes, I have.
And do you have any corrections to your testimony?
No, I do not.
If I asked you the questions set forth in your testimony today, would your answers be the same as set forth in that written testimony?
Yes, they would.
Thank you. And Your Honor, we do have the additional exhibit requested that we'll be filing as Johnson Exhibit 2, I believe.
Yes.
And with that, Mr. Johnson's available for cross.
All right. And let me say, I don't know if we went through the process to accept the Hartzig 3 and 4 and Johnson 2. So let me just make sure we don't have any objections to those. I mean, I've gotten the email. I'm assuming parties have received it as well. Any
Just to clarify, Your Honor, do you mean Hagney 3 and 4?
Oh, yes, you're right.
And-
Hagney 3 and
and
4
Johnson
and
2.
Johnson 2. Yeah, you're right. Thanks. So not hearing any objections, we'll accept those documents and we'll get those filed. Any cross from for this witness, commission staff?
No, Your Honor.
And Renew?
No, Your Honor.
Okay. All right, great. Thanks. You're excused.
High Noon Solar next calls Mr. O'Connor.
You are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Good morning, Mr. O'Connor. Can you please state your full name for the record?
Hayden Allen O'Connor.
Thank you. And where are you employed and in what capacity?
I'm employed at Invenergy LLC, and I am a senior associate of renewable development.
Thank you. And have you prepared and caused to be filed in this proceeding direct testimony consisting of 33 pages and 1 exhibit, as well as rebuttal testimony consisting of 5 pages and 1 exhibit?
Yes, I have.
And do you have any corrections to your testimony?
No, I do not.
And if I asked you the questions set forth in your testimony today, would your answers be the same as set forth in that written testimony?
Yes, they would.
Thank you. With that, Mr. O'Connor is available for cross.
Okay, any questions from staff?
No.
And Renew?
No questions, Your Honor.
Okay, so I did have one clarification. I think witness O'Connor may be the best person to ask. I saw that my instructions for the applicant in refiling the application exhibit included adding the sample good neighbor agreement, which I saw in a filing that was submitted today. Or actually it was the sample local cooperative agreement as well. And maybe I'm getting let's go off the record for a second. Let me just double check. Yeah, I'm mixing my my cases up here. That's possible. Oh, maybe I did mix cases up. Oh, here we go. So yeah, so we applicant sent in the good neighbor agreement form as a separate filing as appendix W, and then included it in the application exhibit. And also it looked like there was a filing that was already on Earth. That was the local agreement. So that's so I guess my question is that's the form version that looks like, is the starting place for the final version to be the version that will need to be finalized. And I guess my question for the witness is, what's the status of a final local operating contract being reaching final agreement?
High Noon Solar is engaged with the local municipalities in negotiation of these agreements. I believe we have responded to a data request with an update approximately 2 months ago. Cooper Johnson on our team is leading these efforts in the field.
Okay, and any time frame we can expect to get the final version, get the contract finalized?
It is our preference to execute these agreements as soon as possible. Some of the municipalities have been more responsive than others, and we are diligently working to meet them on their schedule to execute these contracts.
Okay, so it's a little sticky place for us in terms of our process. But for some reason, some other applicants have filed the final versions with us. And it sometimes that happens. Well, when it's happened before the record is before the commission. So before the commission takes up review of the record, some solar applicants have filed those final version of the contracts. So I was curious if High Noon Solar would be willing to do that, at least within the time frame of the deadline for the CPCN to be issued, just so we keep these proceedings on sort of a similar track. Any opinion about that?
Your Honor, I think to the extent, I mean, I don't want to commit us to filing this if it won't be done. So I just want to make sure I understand that. Is your question just if it's finished, or are you asking that we make an effort to finish it?
No, I don't think I want to dictate that, but just if it's finalized before the commission reviews the record, we could have the final versions filed.
High Noon Solar can agree to file the final executed versions once available.
Okay, and let's just mark that O'Connor 3, and we'll just hold that make that a placeholder in case the timing is such that you can fulfill that agreement.
And Your Honor, I'm so sorry. We do actually have some rebuttal to respond to staff witnesses testimony. I was thinking it was just your question, so I wanted to go through yours. That's my mistake.
Oh.
So
Did I have specific questions? Did I have previously stated questions?
no, it was just that. It was
Okay.
just
Okay.
the agreement.
Sure. Okay. Yeah. Well, okay. Let me just. Okay. Yes. Go ahead. I haven't excused you yet, so you got lucky.
Sorry about that.
That's okay.
So, Mr. O'Connor, have you had an opportunity to review the rebuttal testimony of PSC staff and particularly staff witness Wu?
Yes, I have.
On page 2 of Mr. Wu's rebuttal, he proposes an amended version of an order condition related to providing final detailed engineering plans. Are you familiar with Mr. Wu's proposed amended order condition?
Yes, I am. In summary, Mr. Wu recommends that High Noon Solar be required to provide final detailed engineering plans for the project within 30 days of the project in service date, and commission staff shall return the project to the commission if they identify safety or reliability issues after reviewing those plans.
Thank you. And how does Mr. Wu's current proposal differ from his initial proposal in your view?
Mr. Wu clarified in his testimony that his order point would require High Noon Solar to provide post-construction design plans, often referred to as build plans, and would have 30 days to do so.
Do you agree with this, Mr. Wu's proposed amended order condition?
No, I do not. As noted in my rebuttal, I believe the condition is redundant with the commission's continuing jurisdiction.
Can High Noon Solar provide these post-construction final design plans to the commission within 30 days of the project's in-service date?
It's possible, but unlikely. The as-build plans are the final set of plans developed for the project, and they stay with the facility throughout operation. They can't be completed until the project is 100% complete, meaning construction is complete, all circuits have been energized, performance testing is complete, all temporary civil work is removed and restored, and any remaining punch list items are completed. The project could be considered electrically in service before all of these steps are rendered complete. In fact, it is often the case that the punch list items take longer than 30 days to complete. For example, a project may be placed in service during the winter months, but a contractor may be unable to complete remaining punch list items like final civil work until the following spring because of seasonal constraints.
Thanks. So given these in the field construction requirements, do you have a recommendation for a timeline for providing these post-construction final design plans to the commission?
I would recommend that the order condition language be changed to require plans to be provided to the commission as soon as practicable.
And do you have any other comments regarding Mr. Wu's proposed amended order condition in his rebuttal? Excuse me.
I would reiterate that the second portion of the proposed condition, which mandates that staff return the project to the commission in certain circumstances, is unnecessary and could increase the workload for the commission and the regulatory burden on the project. I would also note that any as-built plans will need to be kept confidential for safety reasons, as well as other proprietary business reasons. I would request that any order condition requiring final design plans recognize that the plans can be filed confidentially with the commission.
Thank you, Mr. O'Connor. And with that, Mr. O'Connor is available for cross.
Okay, any questions?
None from commission staff at this time, Your Honor.
And Renew?
And none from Renew Wisconsin.
Okay, great. Thanks very much. You're excused.
Thank you.
So,
I believe that's everyone for the applicant, Your Honor.
okay, great. So let's turn to renew. Fixing my list. All right, so we have witness Vickerman in front of me here. Let's swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, just state your name for the record.
Michael Vickerman.
All right, and you filed for Renew Wisconsin direct testimony and 3 exhibits, is that correct?
Initially 3 exhibits, Your Honor.
Yes, okay, perfect. So then subject to my ruling, we'll be accepting direct Renew Vickerman as modified and exhibits Vickerman 1 and 2. So for those documents, are they with the changes that we've recognized, are those documents complete and correct to the best of your knowledge?
Yes, they are.
Okay, do you have anything else to add?
No, Your Honor, I do not.
Okay, any questions for the witness?
No, Your Honor.
None from the applicant, Your Honor.
Okay, thanks very much. You're excused.
Thank you, Your Honor.
All right. Turn to commission staff.
Commission staff calls Adam Ingwell to the stand.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Adam Ingwell,
What is your position at the Public Service Commission of Wisconsin?
Environmental Affairs Coordinator.
And how are you involved in this docket?
I assisted with preparation of the environmental assessment and then took over the environmental analysis role after that, including providing testimony.
And did you file or cause to be filed direct testimony in this docket?
I did.
Are the statements and representations in the testimony that you filed in this docket true and correct?
Yes.
And do you have any additions or modifications to your testimony at this time?
No, I don't.
Thank you, Your Honor. The witness is available for cross.
Okay, well, just to start, I did have a question regarding witness O'Connor's statement. It's on one of the comments that was provided. And it deals with the your witness Ingwell, your proposal to avoid construction between May 20th and October 15th. So I was just curious, I don't believe you addressed that in further testimony. So I just wanted to confirm if your opinion has changed or not with respect to that no construction period.
This question is for me, sorry.
Yes.
My opinion has not changed.
Okay. All right, I think that covers my question there. Okay, so any cross from the applicant?
No, Your Honor.
And renew?
No, Your Honor.
Okay. Okay, you're excused. Thanks very much.
The commission calls Jerry Rademacher to the stand.
See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right.
Please state your name for the record.
Jerry Rademacher.
And what is your position at the Wisconsin DNR?
I am a water management specialist in the DNR's Office of Energy.
And did you file or cause to be filed direct testimony in this docket?
Yes.
Are the statements and representations in the testimony that you filed in this case true and correct?
Yes.
And do you have any additions or modifications to your testimony at this time?
No.
Your Honor, the witness is available for cross.
All right. Any questions, starting with the applicant?
No, Your Honor.
Okay, renew?
No, Your Honor.
All right. Thanks very much. You're excused.
Thank you.
The commission calls Stacy Rowe to the stand.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Please state your name for the record.
Stacy Rowe.
And what is your position at the Wisconsin DNR?
I am the Endangered Resources Utility Liaison in the Office of Energy.
And did you file or cause to be filed direct and rebuttal testimony in this case?
Yes, I did.
Are the statements and representations in that testimony that you filed true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No.
And did you hear the testimony of witness James Hartzig here today?
Yes, I did.
And does what he stated about High Noon's vegetation management strategy change your position?
I just have a couple of maybe clarifications on what he was saying, or perhaps thoughts. One was regarding the height limits to the seed mixes. I do know that there are certainly a number of native pollinator species that get no taller than 18 inches and that other solar sites have incorporated into their seed mix. In addition, this really should not increase the fire risk any more than any other seed mix with or without those pollinator species added in. In addition, regarding establishing native species in former croplands, I would anticipate, like any other solar site, that this area is going to be disturbed and have bare soil and not need any kind of broadcast herbiciding in order to start seeding and get that established. The mowing and spot herbicide treatments, as referenced in their vegetation management plan, should address any of those concerns of weeds or invasives coming in, so long as that is followed.
Thank you, Your Honor. The witness is available for cross.
All right. So I just want to follow up quickly with what you said and then address the comment that I provided in the offered evidence list. Well, you just mentioned that there are solar sites that place forbs and pollinator species in the under array area. Is that right?
Correct.
Which projects utilize those species?
Oh, I'd have to look. There's a few of them, both I believe approved projects currently under review by PSC, as well as non-PSC approved projects.
Okay. All right. And just to be clear, that's in the under array area.
Correct. Yes.
Okay. All right. Okay. So I just wanted to turn to my question. There was a statement that you had made in your rebuttal, page 2, that explained, I guess, kind of spoke to an opportunity to review and comment on the vegetation management plan. I was just wondering if you could explain in greater detail how the vegetation management plan review and comment process that you suggested as an alternative from ordering High Noon Solar to include pollinator friendly vegetation in the solar array mix would work.
Sure. An order point from the commission requiring the removal of fescue would be the preferred mechanism to address this concern. However, short of that, an alternative approach could be something similar to the order points used in previously approved PSC solar projects, including Two Creeks, Onion River, and Badger State. Specifically, the order point for Onion River states that the applicant shall work cooperatively with commission and DNR staff on the development of a practical site-specific vegetation management plan as set forth in this final decision. That order point also went on to state that the pollinator-friendly species chosen should include a variety of species that ensures blooms from spring through fall. So I suppose that project is an example of one that addresses pollinator species being included. By working,
just to be clear, I see it on my on the transcription here. You said ensures springtime
blooms, so flower bloomings from spring through fall, which would benefit the pollinator species. Yep.
Okay. So Onion River,
correct,
is an example. Okay, and that is an example of what?
Of one that had an order point specifically stating that the applicant shall work cooperatively with commission and DNR staff, and also included the native pollinator mix.
And that's in the under array area.
Correct.
Okay. So then just to follow up on the applicant witness's statement, with respect to planting or introducing, I think he said planting or seeding forbs or pollinator species in the under array area after site stabilization occurs. Do you have any opinion on that proposal, that approach?
Yeah, I think it's something that could be looked at. My experience is that it is more difficult to get those species established once a ground cover has already been established, simply because there's no room left for those seeds to be able to get established because it's already densely covered with other species. So in my opinion, it's possible. It would be very difficult to do so though.
Okay. All right, so let's turn to Attorney Bedford. Any follow-up questions from what I've, actually, let's do cross first and I'll give you the chance for follow-up. So any cross from the applicant?
I don't think so, Your Honor. Thank
Okay.
you.
Sure. Renew.
No cross from us.
All right, so any redirect from staff?
No, Your Honor, no redirect from staff.
Okay. All right, great. Well, thanks very much. You're excused.
Thank you.
And the commission calls Cheng Wu to the stand.
There you are. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Right. Your mic may be a little low, so if you could get a little closer, that might help. Okay, why don't we try it? Go ahead, Attorney Bedford.
Please state your name for the record.
Cheng Wu,
And what is your position at the Public Service Commission of Wisconsin?
a public service engineer.
And did you file or cause to be filed direct and rebuttal testimony in this case?
Yes.
Are the statements and representation in the testimony that you filed in this case true and correct?
Yes.
Do you have any additions or modifications to that testimony at this time?
No, I do not.
Did you hear the testimony of High Noon Solar witness Aidan O'Connor here today?
Yes.
And does what he stated about the proposed order condition that you discussed in your direct and rebuttal testimony change your position on that proposed order condition?
Yes, but only in regard to the timeline for the applicant to provide as-built plans. It's my opinion that the commission could find it reasonable for the applicant to submit those plans as soon as practicable, rather than the 30 days as I originally proposed after the in-service date.
Thank you. Your Honor, order conditions. The witness is available for question for a cross.
Okay, great, thanks. Any questions from the applicant?
No, Your Honor.
Renew.
No questions from Renew, Your Honor.
Okay. So I did have one clarifying question, although maybe we have. Oh, this is a little different. I think it's just dealt with some of the wording in your final design plan order condition. So let me just read it. This is what you're expecting to answer anyway. It's kind of it's long-winded, but let's just get through it. So at Surrebuttal PSC Wu 2, lines 10 through 15, your alternative final design plan order condition uses the phrase, and it's quoted, proposed project, while the various proposed construction authorization conditions use the phrase proposed solar PV electric generation facility, BESS facilities, generation tie-line facilities, and all other associated facilities as directed in the application and data request responses, and is modified by the final decision. So my question was, why did you use a different terminology with the different order condition proposed?
That was in response to a separate issue raised in Mr. O'Connor's rebuttal, wherein there was some language change to clarify that the proposed project is more than just the solar facilities and encompasses a lot, the best facilities as well as the other facilities that are being proposed.
Okay, so the more detailed description is the preferred language for the order conditions.
Yeah.
Okay, all right, great, thanks. Excellent. So at this point, we already did. Well, did I already ask for cross? I can't remember now. Yeah, okay. So any redirect from commission from Stephanie?
No redirect, Your Honor.
Okay, great, thanks. All right, well, thanks very much. You're excused. So that's all of our staff witnesses. That's all of the witnesses. At this point, just let me ask, if there's anything else we need to discuss while we're together? We have a post-hearing schedule, and we have, stop the screen share here. We have our post-hearing schedule in place, and we'll have the public hearings later on today. So anything else we need to take care of while we're here?
No, Your Honor.
All right. Well,
Nothing
thanks
from
very
the
much.
commission, Your Honor.
Okay.
No, Your Honor.
Good, thanks. All right, so at